Hello, everyone, and welcome to another episode of the Amicable Divorce Network podcast. My name is Tracy Ann Moore Grant. I'm the founder of the Amicable Divorce Network and the host of the podcast. We are in season 2, and we are going chapter by chapter through the Amicable Divorce Network book, which is called Divorce Amicably, Your Roadmap to Resolution. And we have made it to chapter 65. So we have been going on this journey for some time. So thank you for sticking with us. And so please hit the subscribe button so that you don't miss any of the chapters. I am joined today by Neena Saxena with my office. I'm fortunate to work with her. And we're going to be discussing today a question and topic that we both get asked a lot and comes up in a ton of cases, and that is the difference between legal and physical custody with children. Thank you for joining me, Neena.
Thank you so much for having me and allowing me to share my knowledge with Amicable Divorce Network and people that are going through this difficult process of a divorce or dealing with the aspects of legal and physical custody.
So this comes up with children almost all of the time. Now, I will point out that some states do not, and I believe in some other countries, don't have the differentiation between legal and physical custody, and primarily some states don't address legal custody. So if you are listening and going through a parenting plan, really great to touch base with a professional in your area about this. Most states do have this designation, but it is always best to just double check. So let's just jump right in. What would you say is the difference between legal and physical custody when it comes to kids?
So the way I describe legal custody has to do with 4 subparts under the legal custody umbrella. Legal custody has to do with education, the extracurricular activities, non-emergent healthcare issues, and religious upbringing. And some states might have, another topic or two, but like Tracy Ann mentioned, just go ahead and check. But for the state of Georgia, those are the 4 areas that we are, dealing with.
Yeah. In Georgia, that's what's listed on our parenting plan. I have heard of other areas that have a separate category for mental health. I've seen that from time to time, and some don't have religion or extracurricular or some things like that. So, but regardless of what your state requirements are, the more that you can capture agreements on these type of topics, the more you're going to minimize future confusion on what's happening with the kids or future disagreements. So you could beef up your documents even if it's not required by your state. So legal custody, we are generally talking about those 4 topics. But first of all, I guess I would say if you have joint legal custody, each parent has the right to information about the children.
Correct. So there is legal custody that talks about all 4 of those areas. And then you can go ahead and separate it out into joint legal custody and then sole legal custody, meaning the parent who doesn't have sole legal custody does not have access to any information regarding the child, meaning they couldn't go to the school and request them to be put on the parent portal or get access to their grades. They couldn't go to their pediatrician and get their health records. They couldn't go to their baseball games and get to know their schedule. Any of that falls under legal custody. Now with joint legal custody, both parents have access to all of the information. The parent portals, whether it's through school, extracurricular, or their doctors, being able to be involved in their religious upbringing. However, then you kind of create another sub under joint legal custody that, okay, we're going to make these decisions jointly. We're going to confer with one another. We're going to co-parents. We're going, even though we're divorced and we don't like each other anymore, we're still going to discuss, what is best for our child moving forward, whether it be their extracurricular and determining what sports they're going to play. Do they need to see a therapist and their mental health? Do they need, as the child gets older and 16 or 17, do they need to be put on birth control? So areas that need to be discussed in a normal, marriage where you are discussing this over the dinner table or passing through, these topics still need to be discussed between the parents. However, one parent may agree and one parent will disagree, and that kind of happens.
Never in a divorce.
That kind of happens 99% of the time. It might even happen in your marriage, but one parent will be like, well, I'm doing it anyways, and you just go along with it. When it happens in the divorce scenario under legal custody, one parent is designated as the final decision maker. And it doesn't mean that you have unilateral decision making. It means after conferring with the other parent, giving a good faith effort to try to come up with a decision together regarding one of those four aspects. If you still cannot agree, then the parent who has final decision making on education or extracurricular or non-emergent healthcare or religious upbringing can make the decision on what's best for the child. For example, Johnny wants to do baseball. Mom says, fine, do what you want to do. But dad says he's been doing soccer for the past 10 years. That he has a real chance of getting a scholarship in soccer if he continues with it. Mom has final decision making after conferring and talking it through for about a month or so. They can't come to a mutual decision. Mom can then make that decision saying, all right, Johnny, you want to do baseball? You can do baseball.
And the next question that we usually get after explaining this to clients is, you talked about them discussing it. Like, how much do we have to discuss it? For how long? We call it the cuss and discuss provision. And for parties who maybe are a little bit more high conflict, maybe you have somebody that completely ignores the other parent and won't agree, won't talk, or people who want to excessively talk and no conclusion, can almost never happen. We can build language for parties that need more of a beefed up language in regards to how they communicate, how often they communicate before this final decision is made. That could be customized for a situation.
Correct, because even in sticking with the extracurricular piece of it, it might be important to both parents need to know the aspects of the cost of it. That might be a driving decision also, or how many extracurriculars they're doing, or do they want to switch schools from one district to the other just because they don't want to go to that school anymore and now they want to switch over to another one. So I think discussing and you're going to hate us for saying this, but it's a reasonable amount of discussion, right?
Good faith.
And a good faith discussion. And clients hate hearing that because what's reasonable? You telling the other party that, hey, Brittany wants to do cheerleading and she's done with gymnastics. That's not a good faith discussion. Right. That is kind of unilaterally making a decision. But having a discussion about it, and if the other party doesn't engage and you try to reach out a few times, you've done your part. Yeah. You've made a good faith effort. It needs to come from both sides.
Yeah. And I think it's always a good rule of thumb when you're having these or trying to have these discussions to memorialize that in writing. A lot of people text these days and then their text messages are gone. This might be something to email and keep that email to say, hey, we have this major decision coming up. Do you want to talk about it? Here's the information. Here's my perspective. Give me a call by Friday or, something like that, so that the other person can't come back later and complain that they were never asked, didn't have an opportunity. So always good to memorialize those types of things. So that takes care of legal custody, I think. And so physical custody is the other thing. And this is what people normally think of when they're thinking of custody.
They do. And physical custody has to do with where is the child going to be physically on a day-to-day basis. And there's many different versions that can be created from physical custody. I do want to preface that a lot of people do mistake sole custody and primary physical custody to be the same thing. It's not.
Yeah.
So sole custody is when you have sole physical and legal custody over the child or children, and the other parent who doesn't have sole custody has visitation or nothing at all. And the visitation may be very limited or supervised or nothing.
Yeah. And these are usually extreme circumstances. Like the other parent is in jail. The other parent is completely unwell and unable to see the children. A lot of people sort of get angry at the beginning of a divorce, which is completely understandable. But I think we hear this a lot. Well, I want sole custody.
Correct.
And so it's really an extreme situation where that would occur. It can occur if that's good for the child, especially for their safety. But if you have two pretty engaged normal parents, it would be rare.
Exactly. So sole custody is something I rarely see. Not saying that I haven't seen it or not that I haven't done it, but it is, as Tracy and you mentioned, it is very rare. The one that I see more often is primary physical custody. Primary physical custody is defined as where the child is going to be primarily primarily the time. Doesn't mean that the other parent doesn't have parenting time or visitation. I like to use the verbiage parenting time just because the other parent doesn't get visitation. It's
Yeah.
for parenting the child. So the other parent does get parenting time, but it's probably not as much as when you have primary. Other areas are other ways to define it as joint physical custody. Joint physical custody is when each parent has 50-50 custody or close to 50-50 custody, depending on how you break up your schedule. Or one thing is bird's nest custody, where the parents kind of moves in and out of the home that the child are living in, so the child never has to leave the home.
Yeah, the
That
child stays in the nest. The parents
Yeah.
are the birds, and they're the ones that rotate in and out. We used to never see this, but now because of the housing market, I've seen it more and more.
I see it more and more, but I will say that I don't see it on a permanent basis. I see it more on a temporary basis, that it's a band-aid to fix the current issues that are happening while the parents are going through the divorce process and trying to figure out all the financials and what's best for the children, so they're not disrupting the children multiple times during the divorce process.
Yeah, and it's particularly something to look at if you have a special needs child who would be disrupted by going to different environments. But yeah, I don't see people doing that for 10 years. It's normally, on a temporary basis or, very short term to try to get through a certain period. Along with the physical custody, then we get into, holidays and, different aspects of that. So that's part of the physical custody aspect.
That is part of the physical custody, and defining all of that, you would need to be very detailed in how you foresee and which holidays you want with the child and when the other parent gets the child. And it's going to be very detailed oriented in your parenting plan, which needs to be in there, as you need to know where the child's going to be and from what days. Is it going to be from release of school, or is it going to be, your normal weekend time that it starts? And when are they returned?
Yeah, people need to have a parenting plan that has so much detail in it that a stranger, let's say they're at the school, can pick up that parenting plan and know that little Johnny is supposed to be, with one parent or the other at 3 p.m. so that there is no disruption. And sometimes people that do get along a little bit better get very frustrated by that level of detail. But I know we often see where people may even have a good divorce, but afterwards things break down when somebody gets, new partners or moves or something. And so usually everybody goes through a period of time where they have to reference that parenting plan, and you want it to be really good.
So what I tell my clients are, there are three types of people that go through a parenting plan in a divorce. You're gonna either create a Bible and stick to it and literally go through page by page, every week, and be like, all right, where is little Johnny supposed to be and who has the parent? And they're gonna stick to it to the core until the child graduates and turns 18. Or you're going to have this parenting plan and you're going to stick it at the bottom of the drawer and never look at it, because you co-parent really well with your ex and you're going to do what's best for the child and really meet the child where they're at. Or you're going to live somewhere in the middle.
Yeah.
Right? And this is why I tell my clients, the more details are not going to hurt you. Right? You can always work it out with your ex to figure out, if this Thanksgiving is really important because you believe it's grandma's last Thanksgiving, that she give it to you and you guys exchange Christmas or something. That's where co-parenting comes in. That's where life after divorce, you still need to communicate.
Yeah.
So I think it's very important. The more details you put in there, the better, because if you're left with open-ended information, well, we didn't do our jobs as attorneys.
Exactly. Yeah, we need a stranger to pick up that parenting plan and to know exactly what's happening, as well as a party who's now having an argument with the other person 5 years from now. They need to be able to rely upon that parenting plan. We always hope they shove it in a drawer and never look at it. But at some point they are going to pull it out and look at it. Another thing just to hit on very quickly is I think how physical custody and legal custody overlap sometimes. And so I think that's something that people need to think about as well, is that usually the child's school is determined by primarily where they live. And so often that person also has final decision making in education, because those two could conflict with one another. So if the child's primarily living with mom and and dad as final in education really doesn't have a choice because the school won't let you just pick a different school unless we're dealing with a private school, but those two are often hooked together.
They are. So where the child is going to be primarily, it's going to determine who has final decision making in education and possibly even extracurricular, because if mom lives in one county and dad decides to move 50 miles north of the county that they used to live in, well, then mom needs to have the extracurricular, because you're not going to drive 50 miles to go to a soccer league game up there on a weekly or bi-weekly basis.
You would be surprised. I had that in 2 cases, and they had
I just resolved one, and there's ways to get creative with the extracurricular, and it doesn't have to be an all or nothing. And I think sometimes clients believe that it has to be all or nothing and I win. If I get the extracurricular, I win the child. And you have to change your mind frame in that, because you can always get creative with creating the parenting plan. For instance, with extracurricular, both parents want to be very much so engaged. There's one thing that I always suggest. I'm like, well, most extracurriculars run through the school year. One parent gets the fall, which defining what fall means is really important. August to December, and the other parent gets the spring. What does spring mean? Spring means January to May, and then in the summertime, we define it differently.
Yeah.
So you have to be open-minded to getting creative.
Yeah.
Because if you want a rubber stamp parenting plan, go to court.
Yeah, they'll give you something that's not personalized all day long.
It is not, and it's never going to work for your family, because when you're here at the Amicable Divorce Network, you have the professionals available to you to give you the knowledge to let you know that these options are available, that you can create something that's so personalized to you and your family, whether it comes to the legal custody or even the physical custody.
And every family has unique challenges. You're touching on the extracurricular because we see that as a conflict point so often, because it determines both parents' schedule. Sometimes people choose travel sports that are time consuming and expensive, or somebody coaches the team, but the other person has the final on that. And there's just these conflicts. So if there is a pressure point in your family over a particular topic, you have the opportunity with an amicable divorce to really sit down, get some customized language to, resolve those conflicts. How are we going to handle them? What's exactly the issue here? Whereas if you go to court, may not even ever get to present that evidence. You may get a very short amount of time, and this actually would be a huge issue in the future. And so that ends up being a problem. One other thing just to touch on that people often don't put in the legal or the physical custody part that I think is important are rules about technology.
Yes.
When does the child get a phone? When do they get social media? Who pays for the phone? Where is the phone? I've had kids unfortunately get 2 phones, different things like that.
And that's horrible for the child. I'm just going to put it out there that the child is just going to feel split in half and torn, because one parent says, well, I bought you this phone, so this phone, when you go to dad's house, this phone is not going with you. So Tracy, and that's a wonderful aspect that I see a lot that I'm putting in and bringing it up with my clients. I see that your child is 5, but I bet your child has a tablet.
Yeah.
So where is that tablet going?
Yeah. And people have these concerns that, the tablet is being tracked, so I don't want it in my home, and there's just easy things that you can do with that. I mean, obviously, one parent knows the child is in the other parent's home.
Correct.
And different things like that. But you have the opportunity when you're settling your case to be nuanced, to customize, to bring in these other topics. Correct. Whereas if you go to court, they're not going to touch a technology issue. It's a huge pressure point for people, but they're not going to get into it.
And it's going to take a while before the courts even decide to implement that into our, parenting plans that are created by the courts.
Yeah.
So I don't foresee that happening anytime soon, because there are 6-year-olds that I see with cell phones, and then I see other kids that don't get a cell phone till middle school. And, when you're together, you might be aligned on what you believe, but because you're saying, well, I don't want dad calling my cell phone or, my phone, so I'm just going to get the kid a phone. Well, what are the parameters around it? Because there is you have to also consider what are the mental health issues that surround a child having a phone too.
We could do a whole other episode on kids and technology, and we might just do that because it's something we're seeing more and more and more. Neena, thank you so much for this conversation and for your chapter. If people want to reach you, how can they find you?
They can find me through my email, which is available through the Patterson Moore Butler website or through Amicable Divorce Network. I'm listed as a member.
And if you're driving and listening to this, her information will be in the show notes. So just save this episode and come back to it. Neena, thank you so much.
Thank you for having me.
All right.